Namaskar. I am Dr. Nalini Avinash Wagmare. This is my brief information written on this first slide. Presently, I am working as a associate professor at Tilak Maharashtra Vidyapith. Today, our topic is related to the Judicial Plan of 1793. So, under that judicial reforms of Cornwallis introduced he reformed the judiciary system in India. He introduced so many reforms, but basically today I am going to focus on Judicial Plan of 1793. Before that also Judicial Plan of 1787, reforms of 1790, and later on Judicial Plan of 1793. But today only focus on one reforms, that is the 1793. Then what points involved in Judicial Plan of 1793, its merits, demerits, and some reference books we have to study related to this. The Judicial Plan of 1793, due to over-centralization of power in a single authority, that is collector of the district, the administration of civil justice system was badly affected. It was the result of assigning the revenue and civil administration to a single person. The experience revealed that the collectors were more serious in revenue collection and they neglected the administration of civil justice. The collectors were given a commission on the amount of the revenue collected by them. So, when the British East India Company and when the given the authorities to collector to collect the revenue and do the administrative system, that time most of the collectors very involved in the collecting only revenue system and became as a rich, and they are neglected the civil justice or administrative system. That's why this act given some reformed things to them. To remove these defects of the judicial reforms plan of 1719, Lord Cornwallis introduced another judicial reformative plan to be called the Judicial Plan 1793. This plan was also known as Cornwallis Code because he introduced that, and some rules regulation mentioned that. That's why it is called as a Cornwallis Code. This code was consisting of 48 regulations separating the judiciary from the executive, which is the very turning point of this act, because previous executive and judiciary both are same. Now we introducing this act, both are different work and different work distribution done by this act. Even the executive action could be scrutinized judicially. The various provisions of the Judicial Plan of 1793 may be studied under the following heading. First one, separation of revenue and civil functions. Then what steps taken by the Cornwallis to reform the judiciary system by introducing this act? Under the Judicial Plan of 1793, Lord Cornwallis realized the defects in the existing system of combination of revenue collection and civil administration, vesting in a single person called collector. So he reverted back to the system of separation of revenue and civil administration, which existed before his Judicial Plan of 1787. Under the Judicial Plan of 1793, the power of civil administration was taken away from the collectors and they were given exclusive power for collection of revenue. They were to work under the supervisory control of the Board of Revenue, which was ultimately controlled by the Governor General and his council at Calcutta. However, cases relating to the revenue matters were to be decided by the Official Diwani Adalats. Appeal could be preferred against the decision of the Official Diwani Adalat before the Board of Revenue. Even civil cases were to be tried by the Official Diwani Adalats. The power to administer civil justice and also power to decide revenue case was taken away from the collector. Then the working of civil courts reorganized by introducing this act. Under the Judicial Plan of 1793, the system of civil justice was reorganized with the view to make it more efficient and prompt. In each district of Bengal, Bihar and Orissa, a Mufassal Diwani Adalat was established for purpose of civil administration. A company's judge was appointed to preside over the functions of the Mufassal Diwani Adalat. In the revenue matters, the appeal against the decision of the Mufassal Diwani Adalat was to lie before the Board of Revenue, and further, second appeal against the decision of the Board of Revenue was to be lie before the uh, Governor General and his council at Calcutta. However, in civil matter, the appeal was to lie before the provisional court against the decision of the Mufassal Diwani Adalat. Even the executive action of the collector was subjected to judicial control of the Mufassal Adalat. Thus, the Mufassal Adalat checked himself dictating attitude of the collectors. So here we find the powers of the collector and made the judiciary once again in a good manner. Then appeal to be preferred to the provincial court. Irrespective of the value of subject matter in all civil cases, the appeals could be preferred to the provincial courts of appeals. As stated earlier, the territory of Bengal, Bihar, and Orissa was divided into four divisions, namely Calcutta, Patna, Murshidabad, and Dhaka. In these places, the provisional courts were established to hear civil appeals from the Diwani Adalat. It was an appellate court at the division level. Then the provisional court of appeal was presided over by 3 English judges who were appointed by the company. The provisional court was also empowered to decide cases referred to by the Sadar Diwani Adalat or the company. The provisional court was also competent to deal with the corruption cases against the judges of the Mufassal Diwani Adalat. Further, it could refer the matter to the Sadar Diwani Adalat for taking appropriate action. If the charges against the judges of the Mufassal Diwani Adalat were proved, they could be removed by the Governor General and Council. So, strict action taken by the Mufassal Diwani Adalat and their work. If the value of the subject matter was not more than 1,000, the decision of the Provisional Court of Appeal was final. However, if the value of the subject matter exists ₹1,000, a further appeal was to lie before the Sadar Diwani Adalat. It is to be noted that the Sadar Diwani Adalat was consisting of the Governor General and his council. Further, if the value of the subject matter existed ₹5,000, an appeal was to lie before the King in Council called the Privy Council. So, according to case and its subject matter depend. Then creation of subordinate judicial service. In those days, the Mufassal Diwani Adalats were constituted in each of the district headquarters. These courts were overburdened with the judicial works and most of their valuable time consumed in deciding the petty cases. With a view to remove this problem, Lord Cornwallis introduced the system of subordinate judicial service. Thus, the subordinate courts under the immediate control of the Mufassal Diwani Adalat were created. The system of subordinate judicial service was introduced to save the litigants and witnesses from traveling a long distance to reach to the district headquarters of the Mufassal Diwani Adalats. Then establishment of Munsif's Court. At grassroots level in each district, the post of commissioners and Sadar Amins was created to facilitate the litigants. Later, they were called Munsif. They were competent to decide the cases involving the value of the subject matter to more than ₹50. However, the Munsifs were to be appointed by the Mufassal Diwani Adalat after obtaining the approval of the Sadar Diwani Adalat. So, they have to take the permission of the Sadar Diwani Adalat. Then Registrar's Court. Another subordinate court was the Registrar's Court. These courts were given power to decide the cases up to ₹200. The decision of the Registered Court were subjected and required to be countersigned by the Mufassal Diwani Adalat to attain the legal sanctuary rather validity. However, a revision was to lie before the Mufassal Diwani Adalat against the decision of the Registrar's Court. The Registered Court was to be presided over by the covenanted servant of the company. No other person could be appointed to preside over the Registrar's Court. that person must be belong to the company. The experience revealed that by setting up of the registrar's court, the considerable amount of workload was reduced in the Mufassil Diwani Adalat. Then the another feature of this act is the exemption from court fees. The Judicial Plan 1793 of Lord Cornwallis abolished the court fees system. The litigants were not required to pay court fees except the pleader's fees and other charges for the purpose of litigation. Thus, litigation became cheaper in this time. The system of criminal justice improved. Under the plan of 1793, the system of criminal justice was improved from the lowest level. The power of criminal justice was withdrawn from the collectors and was transferred to the judges of the Mufassil Diwani Adalat. Another significant change brought by the Judicial Plan of 1793 was that of the circuit courts and the provisional courts of appeal were merged to become the 4 courts of appeals, one each at Patna, Calcutta, Murshidabad, and Dhaka. This is also a special feature of this act or this plan. Then the system of criminal justice improved. Under that, these courts of appeals and circuit courts were to be presided by the Englishmen judges only. The administration of criminal justice was divided into 2 divisions. The senior most judge was consisting of 1 division and other 2 judges were consist of the other division. Firstly, the criminal cases were to hear by the court of circuit court. Thereafter, the matter in the question was to be considered by all 3 judges of the Mufassil Diwani Adalat. But the system of Sadar Nizamat Adalats remained unchanged. Under the Judicial Plan of 1793, an appeal was to lie against the decision of Mufassil Diwani Adalat. The superiority of the Sadar Nizamat Adalats over the Mufassil Diwani Adalat was maintained in this plan. Then appointment of Indian law officers is also a special feature of this plan. Under the code of Lord Cornwallis, that is the Judicial Plan of 1793, the assistant of Indian law officer, that is Pandit, Qazi, and Muftis, was taken in the administration of justice at all levels of judicial hierarchy. So if a person belongs to Hindu, then the Pandit has to take the note, then Muslim, then Qazi, then others. Thus, the participation of Indians in the administration of justice was introduced for the first time in the plan of 1793, which is the very important and turning point, where the Indians also involved for giving the judgment there. These Indian law officers had to expound the personal laws, thus they played a significant role in the administration of justice during the British regime. However, these Indian law officers could be removed by the Governor General and his council on the ground of incapacity, misconduct, and corruption. If person involved in these 3 things, he is removed from the office. So he must be a good one and biased one. Then introduction of advocacy, also one more point involved in this plan. Earlier, the litigants were represented by their agents of themselves. Notably, these agents of litigants were laymen as far as law was concerned. The Code of Cornwallis has introduced the legal profession and litigants were permitted to have legal profession to plead their case before the various courts existing at that time. Then these legal professionals were called wakils. Today also we call even in village level, district level. Anyway, today also we call advocates as a wakil also. So that time that was existing. They were entitled to charge moderate fees from their clients as per the schedule provided by the Code of Cornwallis, that is Judicial Plan of 1793. The Sadar Diwani Adalat was empowered to entertain complaint against the wakil if it involved professional misconduct with the client, was competent to remove such wakil. If he bribed by his client, the wakilship was removed by his duty. Under the Judicial Plan of 1970, the appointment of public prosecutor was, sorry, by mistakenly here written this 1973, actually it is 1793. Under the Judicial Plan of 1790, the appointment of public prosecution was proposed and also provision for appointment of governor pleader was made. Then fixation of land revenue system. Under the Judicial Plan of 1793, important changes in the system of revenue collection were introduced. Lord Cornwallis proposed the permanent settlement of land revenue. He could convince the director of company to adopt a reform system of revenue collection. Under his plan, the Jamindars were made the owners of the land, and to maintain their ownership over the land, they were required to pay fixed land revenue to the government after collecting the same from the small farmers. So here the fixation of how much Jamindar has to collect from the small farmers. Then reconstruction of police machinery. Under the Judicial Plan of 1793, the police system was subjected to reconstruction. The territories of Bengal, Bihar, and Orissa had undergone a far-reaching improvement in the police system. Earlier police system held by farmers of land, landlords, was abolished under this plan. So special appointment by person. Areas covering 20 miles was under the control of Daroga, and there was a Kotwal under whose supervision there were several Darogas. These police officials were responsible for maintaining law and order and also public peace. Till today we also know that the police duties, because they also mention the law and order and also public peace by doing their work. That is also existing at that time also, and in Cornwallis plan also this was mentioned there. They were under legal duty to apprehend criminals and bring them before the court to prove the offense. However, these darogas were provided with the armed constabulary for efficient discharge of their functions. Then what were the good points we found in this Judicial Plan of 1793? First, merits, then later on we find demerits also. Undoubtedly, the Judicial Plan 1793, popularly known as the Code of Cornwallis, brought a greater improvement in the administration of civil as well as criminal justice system. Whereas in earlier plan, criminal justice was neglected, but in the Cornwallis, it was considered that one. Then the Lord Cornwallis affirmed further the principle of separation of judiciary from the executive. That is also important point. Under the plan of this brought the beginning of the independence of civil justice system in India. The sovereignty of law became the supreme than other persons. That is mentioned. It would not be an exception that Lord Cornwallis brought important changes in the administration of justice. His reformative measures are self-evident that he was determined to remove the corruption, malpractice, and tyranny from the judicial system, which was prevailing at that time. So that was a turning point. Then, however, Lord Cornwallis' judicial reformative measures proved expensive to the turn of about the 4 lakhs to the company profit to them. But the Lord Cornwallis of the view that since company was receiving huge amount of money by the way of revenue collection, therefore the natives deserve to get fair and prompt dealing by the administration of justice. Thus, the approach of Lord Cornwallis was justified. It would be relevant to mention that Judicial Plan introduced a clear demarcation between the revenue collection and judicial system. The justice proving system was significantly improved by the setting of different categories of courts of law under the said plan. How the collectors work, police work, criminals justice work, civil works, he was very clearly mentioned in his plan. It seems that the Judicial Plan 1793 was based on sound principle of division of powers and functions. The history speaks that the provisions of Judicial Plan 1793 were formed on humanitarian consideration of public welfare. So thinks about all people and made this plan implement. So that's a humanitarian basis they are considered this one. And this plan was found the public support and it was proved successful as its provisions were extended to the provisions of Madras and Mumbai. Then what were the demerits in this plan. So the Judicial Plan 1793 undoubtedly brought the improvement in the justice system. It contains some defects also, which are as follows. Creation of several courts of law at all levels made the judicial system complicated and cumbersome. Lord Cornwallis did not trust the Indians before they were kept apart from the administration of justice. At the at the post also, mostly the Qazi, Pandit, Muftis were asked to assess the English judges at all level. Means follow the English judiciary also. So in the principle, the judicial system had undergone improvement, but the quality of judicial officers' personnel was nosedive, as all the courts of law were handled by the servants of the company who were Englishmen and were not well conversant with the language, custom, usage, and tradition of the people of India. So according to English law, they only follow those things. Even the company servants were not well conversant with the existing provisions of law also. As such, board of directors of company in England expressed their concern on this point. In the subsequent years, Indians were given opportunity to participate in the administration of justice and also in the executive functions of the government. In fact, the Judicial Plan 1790 had provisions of qualification of the Indian law, especially the regulation issued by the Governor General and his council to be numbered, arranged, printed, and circulated to all concerned persons who were dealing with the subject. But this Herculean task remained confined to the said plan, and no efforts were made to codify the Indian law. Only on paper it is existing, in practical not taken any steps. The abolition of court fees, though, was appreciated but adversely encouraged the litigation. Moreover, the company suffered loss in terms of money due to abolition of court fees. It is to be noted that despite the aforesaid defects in 48 regulations of Code of Lord Cornwallis, his judicial plan of 1793 paved the way for the foundation of administrative and judicial system in India separately. So that is the one point: judiciary and administrative system, civil and criminal separated, made that one. So Cornwallis Code very important for historical, judicial, and law point of view. So briefly, I have explained the demerits, and importance of this Judicial Plan of 1793. For more detail, you can refer these books. So thank you.